Welcome to today's episode. We're diving into a significant California Supreme Court decision from 2023, Tura Leon versus County of Riverside, which finally puts an end to the doctrine of investigative immunity. It's a ruling that corrects a legal fiction that had shielded law enforcement officers from civil liability for misconduct during investigations for over 4 decades.
Yeah, it's a really important shift. For years, victims of police misconduct during investigations were effectively barred from seeking justice under California law because of a misreading of Government Code Section 821.6. Today, we're unpacking the statute itself, the flawed appellate precedent, the Supreme Court's reasoning, and what this means for civil rights litigation and law enforcement accountability going forward.
Right, so starting with the statutory foundation, Government Code Section 821.6 is really short, just 33 words. It says, and I'm paraphrasing here, that a public employee isn't liable for injury caused by instituting or prosecuting any judicial or administrative proceeding within their employment scope, even if they act maliciously and without probable cause.
Exactly. The key phrase is instituting or prosecuting any judicial or administrative proceeding. The statute's language is pretty clear that immunity applies only to actions connected to the formal initiation or prosecution of proceedings, not to the investigative phase.
And that's consistent with the California Supreme Court's earlier interpretation in Sullivan versus County of Los Angeles asterisk from 1974. The court there confined Section 821.6 immunity narrowly to malicious prosecution claims, wrongful conduct tied to the formal legal process, not the investigation.
But despite that clear guidance, many courts of appeal over the last 40 years blurred that line. They adopted what became known as the doctrine of investigative immunity, extending Section 821.6 protections to law enforcement officers' conduct during investigations, even when that conduct was malicious or wrongful.
Yeah, and the rationale was that since prosecutions necessarily begin with investigations, immunity should cover both. The court's worried about law enforcement officers facing constant dread of retaliation and losing their zeal to investigate crime if they were exposed to lawsuits for investigative conduct.
But the Supreme Court in Tura Leon firmly rejected that reasoning. They emphasized that investigations and prosecutions are distinct both legally and practically. The court even used a really helpful analogy. If you intend to race in the Daytona 500, you have to be at the racetrack beforehand. But that doesn't mean you're exempt from speed limits on the way there.
Right, that analogy really drives the point home. Just because investigations precede prosecutions doesn't mean they're the same thing, or should be treated identically under the law. Different activities, different rules.
And that distinction is critical because investigations often involve direct interactions with individuals, sometimes involving coercion, defamation, or emotional abuse that can cause serious harm independent of any prosecution.
So by rejecting investigative immunity, the court reopened the door for victims to seek civil remedies for misconduct during investigations. That's a huge deal.
Absolutely, and the *AMLU R versus County of Riverside case from 1994 really illustrates the injustice that investigative immunity caused. AMLU was a 15-year-old rape survivor who was slandered and emotionally abused by Riverside detectives during their investigation. They accused her of lying and implied she was involved in the crimes, even though no charges were ever filed against her.
I remember that case. A jury awarded her about $300,000 for emotional distress, but the Court of Appeal reversed the verdict, granting immunity to the detectives under the investigative immunity doctrine.
And the appellate court justified that by prioritizing law enforcement's freedom to investigate without fear of litigation, even if that meant tolerating malicious abuse. They basically said limiting police conduct would subject officers to, quote, constant dread of retaliation.
Which is a pretty stark position, essentially saying law enforcement can get away with malicious or cruel conduct during investigations just to protect their investigative zeal.
Exactly. But Tura Leon explicitly repudiates that rationale, recognizing that such immunity is incompatible with justice and accountability.
Now, the persistence of investigative immunity was partly because victims had an alternative federal remedy under the Civil Rights Act of 1871, Section 1983. That statute allows individuals to sue state actors who violate constitutional or federally protected rights under color of state law.
Right, and Section 1983 has been crucial for victims of excessive force and other constitutional violations by law enforcement. But it has its limits. It generally doesn't cover claims for defamation, injury to reputation, or negligent conduct, nor does it address emotional distress claims unless tied to constitutional violations.
So victims like Amalou or Tura Leon, whose claims involved emotional distress or defamation during investigations, often had no effective remedy under federal law.
Exactly. That gap meant that for decades, many victims had nowhere to turn in state courts because of investigative immunity, and federal law didn't always help.
The Tura Leon decision changes that. It restores California courts' ability to hold law enforcement accountable for a wide range of misconduct during investigations: injury to reputation, financial harm, negligent destruction of property, emotional distress, and even negligently causing serious bodily injury.
That's a significant shift. Previously, these claims were often barred by investigative immunity. Now, the law aligns more closely with principles of fairness and justice, ensuring law enforcement officers can't act with impunity during investigations.
And it reinforces the importance of statutory interpretation grounded in the plain language of the law and prior Supreme Court precedent, rather than judicially created doctrines that stray from the text.
So, to sum up, for over 40 years, investigative immunity allowed law enforcement officers in California to escape civil liability for malicious or negligent conduct during investigations. Tura Leon decisively ends that era.
It reaffirms the narrow scope of Government Code Section 821.6 immunity and restores victims' rights to seek redress in state courts. It corrects decades of appellate missteps and strengthens civil rights protections and law enforcement accountability.
It's a reminder that immunity doctrines must be carefully circumscribed to balance effective law enforcement with protecting individual rights. And Tura Leon helps restore that balance.
Definitely. It's a landmark ruling with real
Helps.
practical impact for civil rights litigation in California.
Helps
Well, that
restore
wraps
that
up our
balance.
deep dive into Tura Leon versus County of Riverside. Thanks for joining us.
Helps
Thanks. Talk soon.
restore that balance, but yet the institution is still implementing barriers that prevents individuals from holding the institution or its agents accountable for harm or wrongdoing that results as a result or in the occurrence of their investigation. They still often escape liability and immunity through their investigative immunity approach. Well, in order to shut that down in the very early process, before filing any legal claim, you should ensure that you are filing it within the 6-month period. And additionally to that, make sure you beat that charge or whatever it is that you're facing before filing that case.